Hello, welcome back to the Paralegal Counseling Training. We continue with labor law for paralegal counselors. Today's topic, we are going to look at law relating trade disputes. It is very important that we understand how to deal with disputes as paralegal counselors, especially the disputes that relates with employer and employees. This is your host, Dr. Tulipo Mwenfumbo, who is taking you in this course. Labor law for paralegal counselors. As I said, the topic here we are looking at it's law relating to trade disputes. We are going to look at introduction and definition, and we'll look at many other topics and subjects. So on introduction and definition, we are going to define trade disputes according to the section 8 of the Industrial and Labor Act. It defines trade dispute as any dispute between employers and workers which is connected with employment or non-employment or the terms or conditions of or affecting the employment of any person. So it defines, there are some keywords here. There is the employer and workers. So in short, it is talking about that the trade dispute is the dispute between the employers and the workers. So we are looking at the employers, the owners of the company, and also the people that are working in the company. I think in the previous slide I said that when we talk about employment, when we talk about labor capital, it is the most crucial and it's the most important capital in the economy. Now, if someone thinks that I can do it without the workers, then he's deceiving himself, because the workers and the owners of the companies, they are like Leo line, whereby one cannot survive or cannot work without the other. So if one of the two thinks that they are the ones that are doing much work than the other, then those, if they fail to reconcile, then there will be no production. The other definition, like from the Indian Act, it says describes trade dispute. It says means any dispute between employers and workmen, or between workmen and workmen, or between employers and employers, which is connected with employment or non-employment, or the terms of employment or the conditions of labor of any person. A workman means all persons employed in trade or industry, whether or not in the employment of the employer with whom the trade dispute arises. So when it talks about employee, we are talking about any person that is employed to work on the certain conditions, and when the dispute comes, that person raises the dispute according to what they feel about the conditions of service and other things that may create conflicts between the employers and the employees. Now, when we talk about trade unions, it is also very important to know, because mostly the dispute comes from the management and also the trade union, because the trade union are the ones that are the representatives of the workers to negotiate and also to look at issues relating to the employers. So they protect the interests of employees. So now when we look at the trade union means any combination, whether temporal or permanent, formed primarily to the purpose of regulating the relations between workmen and employer. So when we talk about the trade union, we are talking about it any grouping which is specifically there to organize and to regulate the relationship between the employers and the employees. So between the employers and the employees, between the employers and the employees, for imposing as restrictive conditions on the conduct of any trade or business. So the trade unions, they are there to ensure that there is balancing up of the workers and also the employers and the employees. So they are now we are talking about our major thing that we are talking about in this subject or in this topic is the trade disputes. Now there are different types of trade disputes that I want us to look at. There is there can be clarified, I think, into four categories. So when we look at the trade disputes, what makes the what brings the dispute between the employers and the employees? There are about four things that we can consider, and number one is interest disputes. So there is what is called interest dispute, and there is what is called grievance dispute, and there is also what is called unfair labor practices and dispute, and also recognition disputes. So that when we look at when we talk about interest disputes, this talks about the interest here refers to gains. So that is where now the employers, the employees or the employers, they have certain interest in gaining. For example, when the employers looks at that, no, we are not making enough profit, so we need to reduce the workers' wages. Now that becomes a interest dispute because their interest is that they may gain. Same like the workers. The workers may raise a dispute that what you are paying us, it is less compared with what you are making. So that becomes the interest dispute. It is whereby there is a gain, and mostly the gain we are talking about, it's the gain in terms of monetary terms. So that is where now one of the two parties is wants to become unfair to the other party, which is doing the production. For example, the employers wants to make more profits at the expense and give the employees peanuts, or the employees, they are not doing much. As a result, the employer is making loss, or he feels he's not making enough compared to the input that he is putting in. So that is what is called interest dispute. Now the other dispute in trade dispute is recognition dispute. The trade unions often enter into a dispute with management during negotiations or collective begging for the benefit of its member employees. So the recognition disputes is that there are there are disputes that arises maybe on positions whereby uh, the the workers need certain recognition in, or for example the benefits. We talk about the maybe the honorarium, or the what will the worker get out after maybe the contract ends. So all those things, all the benefits like health insurance. Also, we talk about the leave days and other things. So all that is in the recognition disputes. Then there is grievance disputes or rights disputes. Now, when we talk about grievance disputes, we are talking about the disputes that comes between the employers and the employees. Maybe there is a certain misunderstanding on the employers or in the employees. So that misunderstanding that may arise, that is called grievance disputes, whereby maybe the employers are not doing what the employees are trying to do, then the employees goes on strike. That becomes the grievance dispute. So in the rights, that is whereby the employees, they are fighting for their rights. So they'll demonstrate it by maybe quitting the work, or maybe they'll demonstrate by them not doing the work. So that is what is called grievance disputes. So grievance disputes, it is whereby also the employers just suspend the work because they feel like the employees are not putting in, and they are making loss. So they'll just say, no, we are going to freeze the operations. So that becomes a dispute, and the trade union begins to negotiate. We cannot do this because there will be these people that will lose employment. I think we have seen this happening mostly in Mopani, whereby in mines, whereby the mine or the employers, especially these investors, will say that we are going to terminate the contracts of members of workers due to that we are not making any profit. And from there, we have heard whereby the trade unions begin to bargain on that one and say, no, we cannot do that because a lot of people will be affected. So that is grievance disputes. Then there is also unfair labor practices. Sometimes there will be a dispute between the employers and the employees because of the unfair labor practices. For example, the health matters. There may be bad conditions in the workplace. They may be working in the place where there is no better safety, and also there may be a lot of danger that may be at work. So that can be also can be classified into what is called unfair labor practices disputes. So in the unfair practices disputes, they may arise a lot. They may raise a lot of things, and mostly they happen at the working place. Now, what are the solutions to the trade disputes? So there must be a solution to any disputes. How can these disputes be resolved? So number one, we have to know that most of the companies, they have got what is called the unions, and those that the companies that have got no unions, still they should have the means and the ways of negotiations in these disputes. So I have outlined the four commonly used methods of resolving disputes. Number one, negotiation. So the management and also the employees, or the management and the workers, must negotiate on certain ground. When we talk about negotiation, it is win-win situation or win-lose situation. So that is whereby they have to reach at the point whereby they come to the agreement whereby no one loses, no one wins. So that is negotiation. So negotiation, it's one way of working out the disputes in the at the workplace. So there must be negotiations, and that is the work of the trade unions to negotiate with the management on the interest of the workers, and also the management also brings their interest. Then there is also what is called mediation. Mediation, it is whereby now you take it to the an independent person. For example, you are the as a paralegal counselor, then you sit the management and also the workers. Then the management brings out their issues or of their concern, and also the workers bring their issues of their concern. That is what is called a mediation. Then you'll be able to listen to them, and one is able to make tell them what do you think about this situation. Don't you think that, for example, don't you ask the workers, you ask, don't you think that if they increase your salary, then there will be then it will mean that the company will start making loss. What do you think in that? And also the way the employers, you maybe you may ask them, if you reduce or the way the workers are, and if they quitted to work, don't you think that you make loss? So it is whereby now you bring to the place where both the employers and the employees reach at a certain agreement, and looks at the issues in the interest of both. That is mediation. Then it's same as arbitration, and also now the final one, it is going to court. Going to court, it is the last thing that has to be done, because that is where now the employers and the employees, now they cannot come to the mutual understanding. They cannot understand each other. So that is that becomes the court issue. And in this matter, then you would find that the law now has to come in, and the justice has to be brought in to see which party is not doing what they are supposed to do. So basically, that is only introduction to trade disputes. So now we are going to look at um, the the laws regarding the trade disputes. So that is what we'll talk about next time. We'll look at the laws that governs trade dispute. We are not going to talk about all everything, but we are just going to quote some chapters or some articles in the trade or the trade act. So that is what we are going to talk about next in the next topic. Thank you so much for being with me. Here is your host, Dr. Tulipo Mwenfumbo, and I believe you are going to join me in the next class, where we are going to look at the laws that relates to the trade disputes. So remember, now we are talking about things to bring in court.